Hello friends, welcome to our YouTube channel. Today we are going to discuss an important topic from the economic survey, the National Asset Reconstruction Company Limited, which was created by Government of India. It is an asset reconstruction company, which was announced in Union Budget 2021-22. It was formed with the purpose of clearing the NPAs in banks. First of all, you have to know what is an NPA and what is an ARC, how does it work. Banks do lending business. It will give funds, it will give loans to the customers, and in return it will get the interest. These loans are nothing but assets for banks. As these they remain as assets as long as the interest and principal are repaid. Suppose if this principal and interest are due for our 90-day period, then they are called NPAs, non-performing assets. When the non-performing assets has increased, the banks will have less capacity to lend more because they will be in losses. They will not be getting any interest, and nor the repayment was done. So when the banks have low funds to lend to others, the growth of the economy will be affected. The problem of NPAs were solved usually before 1993. People used to approach the law courts. That means the banks used to approach the law courts, the civil courts. We all know that if we approach the civil courts, it will take a lot of time, because a lot of appeals will be there from a lower court to some higher court and Supreme Court, etc. So it used to take a lot of time. In 1993, Recovery of Debts Due to Banks and Financial Institutions Act was enacted. Financial institution means NBFCs, other finances. Okay. The one provision is a bar on courts except Supreme Court and High Court. So now there is a complete ban on law courts except Supreme Court and High Court, so that the time period will be reduced. Second is DRT, Debt Recovery Tribunals were constituted. There are many 30 plus debt recovery tribunals were constituted, and there are 5 debt recovery appellate tribunals. For it will act as an appellate authority from the DRTs. Usually DRT used to take up the cases worth 10 lakhs and above, but after 2008 amendment it was raised to 20 lakhs. Even after enacting this act, the time consumed is more. However, when it is less when compared to before the system before 1993, but until the DRT gives its order, the resolution, the assets are within, there will be a complete moratorium on the asset, nor the bank can sell it, and the debtor also cannot claim the asset. This also became a problem for the banks. So later on, the SARFAESI Act was enacted, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. As per this act, now the creditors, that means the banks, were given power to take the ownership of the asset, including right to transfer. So if the debtor unable to pay, the banks can sell the collateral security which was given by that person at the time of taking the loan. And second thing is, if at all the collateral asset is lesser when compared to loan, so the banks can approach DRT and claim the extra money from the debtor. The Insolvency and Bankruptcy Code also gives the power to DRT to consider cases of bankruptcy from individuals and unlimited liability partnerships, because IBC will deal with the companies. One important provision of SARFAESI Act is that asset reconstruction companies were allowed under the SARFAESI Act. What is an asset reconstruction company? an asset reconstruction company is nothing but, suppose this is an asset reconstruction company. So this bank had NPAs. What the asset reconstruction company will do is that it will purchase these NPAs from bank, and in return it will give money so that the bank can continue their lending business. So the problem with the problem of NPAs to the banks can be resolved. What the ARC will do with this NPAs is that it will deal with the debtors and gets a solution with them through legal process. So this is ARCs. See, there are 28 ARCs in India. That means asset reconstruction companies. Even though it is a quite large number, they are better placed for acquiring only small values. See, they are able to solve the problems of NPAs with a smaller value. What if there are the NPA is a 1 lakh crore NPA? It is not possible for a small ARCs. So with this purpose, the Government of India constituted this. See, the various available resolution mechanisms, including insolvency and bankruptcy, Surface Act, debt recovery tribunals, etc., had proved to be useful to a certain extent. However, a large stock of legacy of NPAs are yet to be resolved. While there are 28 ARCs existing in India, due to limited capitalization and low recoveries from the existing portfolios, they are better placed for acquiring only smaller value loans. So, in order to resolve the legacy of NPAs and cleaning up the banking system, the Union Budget has announced for the creation of Asset Reconstruction Company and Asset Management Company, and accordingly, National Asset Reconstruction Company Limited and India Debt Resolution Company Limited were formed. National Asset Reconstruction Company Limited (NARCL) was constituted in July 2021, came into force from October 21. See, this is important. Majority of the stake will be held by public sector banks, whereas in IDRCL, majority is ownership with private sector banks and remaining balance with public sector banks. In NARCL, majority with public sector banks, and Canara Bank will have a 12%. It is a sponsor with a shareholding of 12%. Will have 12%. Now, and the ARC, this ARC will function under 15:85 structure. What is this 15:85 structure? It is nothing but the NRC. See here, the NRCL will aggregate and acquire the stressed assets, and IDRCL in turn provides stressed asset management resolution services to NARCL. See, the NARCL will acquire the NPS from banks. So it will do in 15:85 structure, implying the consideration for acquisition will be, so it will be giving 15% of the value in cash to the banks and 85% in security receipts. Only after resolution with the debtor, this NARCL will be returning complete amount to the bank. Next, what is the relationship between these two entities? As I already said, NARCL will acquire the assets, and in the resolution process, the IDRCL will help. See in NARCL, in acquiring, NARCL will acquire assets by making an offer to lead bank, and the lead bank will offer in hand, with an offer in hand of NARCL, will run on Swiss challenge process. Swiss challenge process is nothing but along with NARCL, whereas ARCs also will participate to take that NPS of the bank. So the bank can give to such ARC which is offering higher value. So that is nothing but asset Swiss challenge process. After acquiring the assets, the IDRCL shall prepare and suggest a proposed restructuring, resolution plan, strategies, etc. for each underlying trust assets. So the resolution mechanism of this nature typically requires backstop from government, as it imparts credibility and provides for contingency buffers. Definitely, the government banking will help to take up the large NPS. Next, The government will provide the guarantee available for security receipts may be involved for completion of resolution or liquidation as the case may be, to cover the shortfall between the actual realization and face value of the asset. See, the government will be giving guarantee for the security receipts. See, the 15:85 structure, 85% is are in security receipts category. So the government will be giving guarantee to that category. In return, the government will charge a guarantee fee on the amount which guarantees, which will increase annually to incentivize the early and timely resolution. Thank you. This is it for today. Kindly subscribe our channel.